Good morning. I usually say good evening. It's good to do an early event. Right on the eve of the holiday. I hope you all have a wonderful one. I'll get rid of that pleasure obligation first. Welcome to all of you and especially to our students of public policy and the Student Advisory Board, which has been so helpful in gathering interest and support for this. Thank you guys for all you did. And it's a pleasure. I'm Harold Holzer, Director of Roosevelt House, and on behalf of President Raab, I'm really glad that you're all here for an extraordinary post-election opportunity. God, so much has happened since the election itself that it's hard to keep track. But today we're going to get an inside view, as only we could get from for the moment, the ranking member of the House Judiciary Committee, soon to acquire another title, I'm certain, in the new Congress. I've known Jerry Nadler for, I hate to say it, but next spring is going to be 50 years, which is really not possible because my official age on the Roosevelt House job application is 53. So I was a toddler when he first ran for West Side District Leader, and I was a cub reporter for the Manhattan Tribune, a West Side newspaper, and I interviewed Jerry and Dick Gottfried, who's still a member of the Assembly from 1970, and it has just been an honor to have known him at the beginning and to know him now at this apex of his career. Jerry Nadler has since served as a member for 15 years of the New York State Assembly, and he was elected to Congress in 1992, which seems like yesterday, and I thought that he was unique in the following, but apparently he tells me, and Jerry Nadler is a student of political history like nobody else in the country. He is amazing. He was elected to fill out a term of a congressman who had passed away and elected to his own term on the same day, which is, I thought was unique, but apparently it's not. He says there were 3 this very year who were elected in a special. So we are honored to have him back at Roosevelt House. He's been here before, for the first time since the election. And we're very grateful to Professor Joyce Miller, who teaches in our public policy program and who has been having a great first semester. She did not promise to deliver her husband, Jerry Nadler, to this event, but she worked at it, and we're really grateful to Joyce. So without further ado, it's an honor to present the rising chairman, Jerry Nadler.
Well, thank you very much, Harold. I've not heard the term rising chairman before, but I suppose in a college or university, that's an apt description. I must say, with respect, I'll just tell you an amusing anecdote since Harold mentioned the special and general elections. In New York law, if a vacancy occurs, the governor calls a special election, to some extent at his discretion. However, there is a narrow window, and if a vacancy occurs during that very narrow window, there's automatically a special election called for the same day as the general election to fill out the 7 or 8 remaining weeks of the expiring term. And that's what happened back in 1992. And there was a special election called automatically, not by the governor, for the same day as the general election. The Republicans did not realize there was a special election. So they had a candidate in the general election for the 2-year term, and I was on the ballot against him. But I was on the ballot unopposed in the special election. I got 100% of the vote in the special election. But we were very concerned. It was a solid Democratic district, but we were very concerned that the only way that I could conceivably lose the election was if thousands of people walked into the voting booth, voted for me in the special, figured they did their job, and walked out without voting for me in the general election. So we had to come up with something to really make sure people understood that what they had to do. So we came up with a slogan, and we put the literature all over the district, and the headline was, "You always wanted to vote twice. Now you can. In fact, you must." and people voted twice, legitimately, and we won both elections. In any event, I am the ranking Democrat on the Judiciary Committee, and almost undoubtedly will be it's usually a pro forma election, and I'm sure it will be the chairman of the committee. I'm going to talk about, let me say just one other thing. Obviously, we live in a time when our democratic institutions are being challenged in a way that we haven't seen probably since the Civil War. I'm not comparing it to the Civil War, that was much worse, but since the Civil War, we haven't seen this kind of challenge to freedom of the press, to judicial integrity, to all the norms that we depend on for democratic government. And obviously, the fact that we now have or will have a Democratic House to provide some checks and balances on the administration to push back will be very important. During the campaign, people would often ask me, they'd say to me, what are we going to do? And my answer always was, we're waiting for the cavalry to ride over the hill. Cavalry arrived about 2 weeks ago, and that will make all the difference. And that will make all the difference. I'm going to talk about some of the things that the House is going to do. I'm going to address four questions. What is the new House going to tackle? What's going to be different? What can we accomplish through bipartisanship? And what can we prevent by exercising our new majority power? The House is going to, there are a number of things the House Democrats want to address, and each different committee will have their own priorities to match the issues under their jurisdiction. For sure, and I think this will apply to almost all committees across the board, the key is a return to the constitutional duty of Congress to provide checks and balances that I mentioned a moment ago. Restoring democratic governance by conducting oversight and making sure that government is being held accountable to the American people. One of the key provisions, or not provisions, but one of the key features of the Constitution is that each branch is supposed to serve as a check and a balance on the other, and the Republicans running the Congress have certainly given the administration carte blanche, have refused to exercise any oversight. That will change. For example, I'm sure the Energy and Commerce Committee will want to look at the administration's disastrous environmental policies, their impact on global climate change, how that may be influencing the destructive storms and fires that now seem to be a regular occurrence, and what policies Congress can enact to protect the food we eat, the water we drink, and the air we breathe. Public office is a public trust, and the midterm elections showed that the American people were sick and tired of the Republican majority refusing to hold the president and his administration accountable and failing to deliver policies that address the problems people face. And let me just mention one thing. It's obviously true that throughout American history, when you had a Congress and a president of the same party, the oversight was, shall we say, less robust than when you had a Congress of a different party. But it was always there, to a greater or lesser extent, not in the last Congress. In the last Congress, the Republicans' basic attitude was they should protect the administration on anything, and they should make sure no inquiries, no hearings, no investigation, no accountability. That will change now. The Judiciary Committee is a critical one, not only because of the issue areas we cover. We have jurisdiction over the Department of Justice, the FBI, law enforcement, immigration, criminal justice, the Constitution, voting rights, antitrust law, the courts, our rule of law, intellectual property, and various others, but because our role is both oversight and accountability and legislative. Our top priority in the new Congress will be to protect, our first priority in the new Congress will be to protect the Robert Mueller and the special counsel investigation from interference by President Trump and his allies. We will conduct strategic oversight to hold the President and administration accountable on issues like the culture of corruption and conflicts of interest that engulf the President and the administration, and we see in every agency the lobbyists and the representatives of the regulated being appointed to do the regulating. The family separation crisis that tore children from the arms of their parents, and we still have several hundred kids who have not been reunited with their parents. And we now learn, just in the last few days, that while the ACLU and others were desperately seeking phone numbers of parents who had been deported to Central America, without their kids, and how we can deport parents without their kids is another question. But we now learn in the last few days that while the ACLU and private lawyers were desperately seeking contact information for parents who had been deported and the kids were still here, that the administration had this contact numbers, had the phone numbers, and didn't bother telling anybody until this week. The Justice Department's decision to no longer defend legal challenges to the Affordable Care Act. It is part of the duty of the President, and therefore of the Justice Department, to take care that the laws be faithfully executed. That's a constitutional command, the main duty of the President. Among those duties, to take care that the law be faithfully executed, is to defend the constitutionality of a law duly passed by Congress and signed by the President against challenges in the Supreme Court. It's a duty of the Justice Department. The only time they're supposed to, or they're supposedly they should escape from that duty, is if they can credibly say that the law is so obviously unconstitutional that there is no credible legal argument that can be honestly made for its constitutionality. No lawyer can credibly make an argument. If they can say that, then they can, and if that's true, then they can say, okay, we can't get up and make a dishonest argument before the Supreme Court. Other than that, they have a duty to defend the constitutionality of acts of Congress. And with respect to the ACA, the Affordable Care Act, sometimes known as Obamacare, as you know, 17 state attorneys general, Republican state attorneys general, have brought a lawsuit saying that it is unconstitutional on various grounds, which I don't agree with, but that's not the point right now. And the administration, of course, was opposing that lawsuit, was defending the constitutionality of the ACA, but when the Trump administration came in, they switched sides. And they said, no, we argue that it is unconstitutional. And that is improper. It's not the role of the Justice Department to argue against the constitutionality of a law unless, arguably, there is no conceivable justification, no legal argument that can be honestly made, and that's certainly not the case. So we'll be looking into that. The Judiciary Committee will also address a robust legislative agenda beyond our investigative agenda, including addressing voter suppression and all sorts of issues about voter suppression and election security, addressing the Dreamers and immigration reform generally. And among the immigration reform, there are a lot of due process issues to give immigrants and asylum claimants due process rights, which they don't have or which have been trampled over, criminal justice reform and gun violence, ensuring corporate accountability and consumer protection. We are going to have a robust, something that nobody in Congress has had in the last 40 years, and that's a robust antitrust agenda, which has not been addressed in Congress for many decades. And advancing equality for all in many different ways. And let me just give you one example of equality that that doesn't get mentioned, that you don't think of as an equality issue, but is an equality issue. You may have read in the New York Times that they had a feature article a few weeks ago, and I think they had a small article today, in fact, about women, pregnant women suffering miscarriages because they can't get a leave from their employer, not to haul heavy boxes around or whatever. In 1978, Congress passed the Pregnancy Discrimination Act, which says employers cannot discriminate against pregnant employees. Unfortunately, the Supreme Court has interpreted that act to mean that if you treat your employees generally okay, you've got to treat pregnant employees okay. But if you're a really terrible employer and you treat your regular employers terribly, well, that's okay. You can treat your pregnant employees equally terribly, as long as you don't discriminate. And therefore, they can get away with lack of accommodation for pregnant women. So I introduced 6 years ago a bill called the Pregnant Workers Fairness Act that says that an employer must make reasonable accommodation to the needs of a pregnant employee, provided that such reasonable accommodation does not pose an undue burden on the employer. Now, those phrases are lifted bodily from the Americans with Disability Act passed in 1990. We've had 28 years of judicial construction telling us exactly what a reasonable accommodation is and exactly what an undue burden is. And if we could pass that law, this would stop this nonsense. You wouldn't have women suffering miscarriages. You wouldn't have women having to choose between their safety for their children or their own health and their jobs and their livelihoods. Now, this is radical legislation, which the New York City Council passed a number of years ago. California legislature passed a number of years ago. The Democratic Assembly in New York passed repeatedly. The Republican Senate didn't. I'm sure that we'll sponsor it in the state Senate by Liz Krueger, and I'm sure that this coming year they will pass it. We will pass this in the House. I've had 160-odd co-sponsors, including 1 or 2 Republicans. I thought initially, I was naive when I first introduced this bill. I thought this was a no-brainer. Everybody would support it. It was not. But that's the kind of advancing equality for all, in addition to all the normal civil rights and voting rights and everything you think of when you hear the phrase equality. What's going to be different in the new Congress? Over the last 2 years, a responsible Congress would have exercised its constitutional duty, as I said, to conduct oversight on the administration. But that's not what the Republican majority has focused on doing. They have worked to block for the president, distracting attention away from the three-ring circus in the middle of the room, pushing a narrative that undermines the rule of law, and refusing to demand any accountability from this administration, and trying to sabotage the Mueller investigation. Americans mostly understand that no one is above the law and that everyone must be held accountable for their actions, and we will be reasserting that in the new Democratic Congress. We cannot ignore policies that rip children from the arms of their mothers and fathers. We cannot hide from the tragedy of gun violence, which rips communities apart without any action from Congress. And let me say one thing about gun violence. We have heard that, the problem of gun violence, it's a mental health problem. We have unstable people with guns and deal with a mental health problem. Well, the fact is that any other country, any other industrialized country, you look at the countries of Western Europe, you look at Japan, I forget the exact statistics, but they're in 2 or 3 digits. 140 gun deaths a year, 150, 160, the United States 33,000. It is a slander against the American people to say that our people are mentally ill at a rate of 10,000 times more than people in Western Europe or Japan. But that's what they're saying, in effect, because they don't want realistic gun legislation, because it would stop sales, which is what it really is about. We will have to deal with that. We cannot pretend that racism and bigotry don't exist. The ADL, the Anti-Defamation League, reports a 57% increase in anti-Semitic incidents just last year. And white supremacists commit heinous acts of violence. We saw the murder of 2 African Americans in a supermarket parking lot in Kentucky, sending explosives to prominent political and media figures, and shooting up a synagogue in Pittsburgh, taking 11 innocent lives. And despite what you read in the newspapers, where almost all the focus on terrorism is Muslim terrorism, jihadists, etc. The fact is that the overwhelming number, I forget the statistic, but something like 75, 80% of Americans killed in what we call domestic terrorism are killed by right-wing white nationalists, not by jihadists or others who get blamed. It's white nationalists, neo-Nazis, that are by far the greatest danger in this country. And we have been, to a large extent, ignoring that. And we have to stop ignoring that, because that's where the real danger is. And it's homegrown. It's not immigrants. It's not people coming from abroad with ill intent. It's homegrown. And we have to deal with that. At the same time, when the president threatens the rule of law by attacking the Justice Department and law enforcement officials, when he attacks the courts and labels the media the enemy of the people, a fine old Stalinist phrase, when he calls the special counsel investigation a witch hunt and does all he can to undermine and interfere with it, that cannot be ignored because it does real damage to our democratic institutions. The president is going to learn very quickly that he and his administration will be held accountable by the new Democratic House, and we're not going to turn a blind eye to the crises in our society. We may not be able to enact all the legislation we want with a Republican Senate and a Republican and worse president, but we can delineate the issues, we can shine a spotlight, we can show what's going on, and we can hold the administration accountable. And we may be able to accomplish some things through bipartisanship. The midterm elections have shown us that Americans want to see a government that is being held accountable to our laws and to the interests of the American people. We have to find answers that address the legal crisis, and these are some things that I hope we can address successfully in Congress. The legal crisis facing the Dreamers, the kids who were brought here as kids and who are American for all practical purposes, but they may not even remember being born in a foreign country. But they hit 18, they find out they cannot get all kinds of benefits for schooling, and they find out they have all sorts of legal problems. They face deportation, and that is simply immoral and wrong. And hopefully we can do something about that. We have to protect our electoral system and defend people's voting rights. We may be able to do some of that on a bipartisan basis, although that's somewhat optimistic. We have to make sure that millions of Americans with pre-existing medical conditions are not denied health care or charged outrageous prices. That we may be able to do after the lesson the Republicans just learned about that in the election campaign. These are just a few of the issues we face as a nation, which have gone unaddressed for too long. They're not Democratic or Republican issues or problems, but problems faced by all Americans, and I hope we can work in a bipartisan way to find solutions. Now, the election has been a referendum on good government, a referendum on the terrible policies of the Trump administration and their enablers in Congress, and a referendum on restoring balance to a system that demands a check on the president. And I don't know, by the way, how many of you saw the news that came out this morning or last night. The raw number of votes by which the Democrats won the House is the largest in American history for a midterm election. 8.8 million, exceeding the 8.6 million of the 1974 Watergate election. So it was a real drubbing or shellacking. Of course, the president won't admit that, but it was. And realists in the Republican Party will admit that to themselves and to each other. Congress is one of the three branches of government, along with the executive and judiciary. It's our job, both legislatively by passing laws, financially by controlling spending, and by keeping the eye on the administration and providing a check and a balance to make sure that the interests of the American people are promoted by pursuing policies that improve people's lives and by opposing policies coming from the White House or from any other place that don't improve people's lives. We will do that. That's our pledge. That's our goal. And we have considerable ability to do a lot of it. We won't do all of it. A lot of the legislative agenda will be a statement. There'll be one House bills. But I will quote a great former Speaker of the New York Assembly, Stanley Fink, who some of you may remember, but he was a great speaker. And I remember when the newspapers and others were demanding that we in the legislature pass strong ethics legislation. And we went into a Democratic conference to start debating what kind of legislation we should pass, how strong we should make it, how far we should go, et cetera. And Stanley got up and he said, among other things, he said the following. He said, if you support the legislation, fine. If you don't, you should say so. Some of you may be tempted to think that it's okay to be silent in the face of legislation that you don't support because it's not going anywhere. And this legislation, and especially the more stronger provisions, will probably not pass the Republican Senate this year. Will probably the state Senate will probably not be enacted into law this year. But it will be. But if we pass it here, it will be enacted eventually. So use your judgment. And I'll say the following. Much of what we pass on a one-house basis this year will become law as the American people see it, as we fight campaigns over it, and as the judgment of a Democratic electorate demands it. So we will start the ball, and we will oppose the administration when they ought to be opposed, which is most of the time. We will cooperate when we can, hopefully some of the time, and we will start the ball rolling on things that will eventually transform a lot of things. Thank you very much, and I'm certainly open for questions.
So we have microphones, I hope. Who's got the mic? So, Jerry, you call it.
Right here.
Okay, wait for the mic because we're on YouTube. You're right.
Thank you so much for being here. I love you. I love the Democrats. All our hard work and advocacy paid off. You answered every question, and you've got a great agenda. There's only one question that I have now, and that is what specific steps are you and your chair leaders doing now and going to be doing to bring the young Democrats who've just been elected to the table, giving them mentorship and important responsibility, a chair at the table, bringing them along, teaching them how to get legislation passed, and teaching them how to interface and build relationships with their fellow members. Because if they keep rebelling, they will sabotage your wonderful agenda, and we will lose 2020.
That's an interesting question. We have a very large freshman class, obviously. We gained 39 seats, maybe 40, depending on the last recount. But we have
40 this morning.
Is it? Okay. That's a good round number. All right, so we gained 40 seats, but we probably have, I don't know, 65, 70 new members because there are new members replacing Democratic members. So we probably have 65, 70 new members, which is a very large freshman class. I was part of a class of 63 new Democratic members. We will, well, I can't answer the question specifically, and they're not all rebels, by the way. There are a wide variety of political opinions, some very progressive, some more moderate, some in between. Obviously, we will talk to them. We'll mentor them to the extent they want to be mentored. I mean, there's always a temptation to think, I just got elected to Congress, I know best, I know what to do. And some may be true. The first thing to do is that, well, after we get through our leadership election, well, first of all, we have, the Democratic caucus is in a very interesting position. You've seen that there's been a lot of criticism that there's a gerontocracy, that there's no movement at the top, and to some extent that's true. And I do believe that the top three leaders, namely Nancy Pelosi as Speaker, Steny Hoyer as Majority Leader, and Jim Clyburn as he'll be the whip, he's now the Assistant Leader, they will be reelected. I certainly hope Nancy is, but hopefully they'll be reelected. But below that level, all the other leadership positions, and we've created a few new leadership positions. So the Assistant Leader, the Chairman of the Caucus, the Vice Chairman of the Caucus, the Chairman of the DCCC, which is now elected for the first, the Democratic Congressional Campaign Committee, which is now being made elected for the first time as opposed to appointed by the leader. The heads of the Democratic Policy and Communications Commission. There'll be a new chairman and three co-chairmen, a couple of other positions. I can't even remember them all. All of these positions are going to be filled by newer and younger members. Probably not by freshmen, but by newer and younger members. 2 years ago, we established for each committee a vice chairman position that can be only filled by someone in their first, I think, 5 terms, and can only be held for 2 terms. That's true in every committee, and we've established a general vice chairman position. I don't. Vice chairman, second vice chairman of the caucus or something, again, only for newer member. So we will be bringing along, and there are some very hot contests for all these. In fact, I joked to someone yesterday, because everybody's seeking my support, not because I'm chairman, but because I'm a vote. I'm a vote in the caucus, that I have to put together a spreadsheet to remind myself who's running for what and who's running against whom and so forth. So we'll have a lot of elections. We'll bring along a lot of new and younger members to these positions.
We have to get everybody.
So beyond that, we'll have to play it one by one.
Let's have our student here. I hope.
Yes, hello. I
Hi.
wanted to thank you first on behalf of all Hunter College students for coming here. Your work on equal rights for pregnant women is truly remarkable, and a cause that would only strengthen that is the Equal Rights Amendment. And recently on Alyssa Milano's podcast of a shadow hearing, we saw that you committed to having a hearing on the ERA as the chair of the Judiciary Committee. So many of us here today are wondering when that hearing will happen and what your commitment to the ERA as chair of the as chairman of the Judiciary
The
Committee looks
hearing will not occur in the first 100 days, but it will occur sometime in 2019. It's on our 2019 agenda. It's not on the first 100 days agenda, which we're putting together. But we will hold it sometime during the year. There are two major questions with the ERA that have to be answered at this point. I've been a longtime supporter of it. I campaigned for it back in 1976 when it was on the ballot in New York. The point of an ERA or of any constitutional amendment that says you can't discriminate against some group on the basis of whatever, sex in this case, is to make that classification what's called a suspect classification, which under Supreme Court law, which means that in order to uphold any law which makes a distinction on the basis, in this case, of sex, you have to pass what's known as strict scrutiny, which is a very tough constitutional standard to meet, which says that to enforce that law, you have to show in whatever given case it may be that the enforcement of that law is necessary to vindicate a compelling state interest, not any old state interest, a compelling state interest, and that enforcing it is the least restrictive means of enforcing that compelling state interest. When I was in law school, they taught us that when the Supreme Court orders you to use a strict scrutiny test, nothing passes the test, ever. It's no longer true. There's some things that do rarely, but it's basically a very tough test to meet. Okay, that's what the ERA would do. One question that we have to look at is the ERA was written many years ago. The Supreme Court has had a lot of decisions against sexual discrimination in the last 30 years. To what extent is that already done? To what extent is that already accomplished through a succession of Supreme Court decisions, and what difference would an ERA actually make? And I'm not saying that in any disparaging sense or any other sense. I'm simply saying this is something we have to take a look at. How important is the ERA at this point compared to 30 years ago, given what the Supreme Court has done? So that's the basic question we'll ask. And if the conclusion is that it hasn't largely been done, if you can show real differences that it would make, I would certainly support it.
So I have a follow-up.
Yeah.
Do you go back to the original, if it's the same language, do the states that ratified count as already ratified, and do the states that rescinded of questionable legality, does that count as rescinded?
I don't know the answer to that question. Now, Congress, when it passed, well, all the Constitution says is Congress proposes an amendment by 2/3 vote in each house, not either, in both houses, and then 3/4 of state legislatures have to ratify. It doesn't put a time limit on it. So one of the amendments Congress in 1790 proposed 12 amendments to the Constitution. Numbers 3 through 12 were adopted and became the first 10 amendments, the Bill of Rights. Numbers 1 and 2 were not adopted. Number 2 was eventually ratified about 20 years ago, having hung around for 200 years. It was ratified about 20 years ago. It's not a terribly important amendment. It says that Congress can't increase its salary during the current term. So if you want to increase your salary, you have to do it for the next term. Okay, but the ratifications of states 150 years ago counted. In recent decades, the last, 50, 60 years, when Congress has proposed a constitutional amendment, the proposing resolution, be it resolved, we propose the following amendment to the states, has generally had a 7-year time limit. The ERA had a 7-year time limit, which expired back in the late 70s, and Liz Holtzman passed the bill through Congress extending it for another 3 or 4 years. That expired. The constitutionality of that time limit has never been adjudicated. So it may be that the court would hold that if, I forget how many states ratified the ERA, 30, or 35, so that means you only need 3 more. So if you got 3 more states, and that means you don't need congressional action, if that is correct. But if you got 3 more states, someone I'm sure would run to court saying, well, this doesn't count because the legislation abolishing this 7-year time limit was or was not valid.
I'm just glad I got to ask a follow-up without having to pass this. Tony, did you have a question? I do. First, wait here for the mic.
Thank you. You're going to be a very busy man next year.
Yes.
So stay healthy. Get your pneumococcal pneumonia vaccine. My question really is quite simple. Does the House have the power to protect Mueller in the absence of support from the Senate?
We have certain powers. There's certain things we can do. We have demanded, I and several other committee chairs, retention of all documents. That makes it, apparently, I'm told by the lawyers, that makes it criminal for them to destroy any documents. So we've done that. If Mueller, well, if Whitaker tries to dictate to Mueller, he has to notify Congress. In other words, if Mueller wants to issue a report and he says no, he's got to tell us. If Mueller issues a report and he pockets it instead of giving it to Congress, he's got to tell us. If Mueller wants to indict someone, he says don't, he's got to tell us. So we would know those things, and we would certainly make them public. In addition to which, the real question, I don't think we could force somebody's indictment, although we could raise holy hell about someone not being indicted if Mueller thought they should be. But we could make sure, the biggest question is we could make sure the information gets out. For example, let's assume that he wrote a report and Whitaker tried to pocket it. We could subpoena the report. Our committee could subpoena the report. They would presumably fight the subpoena in court, and that might last quite a while. We could also ask Mueller to testify. He would not oppose that, presumably, and we could then say, Mr. Mueller, what do you know? Yes, we could do that in open session. What do you know? What can you tell us about what's in the report? I presume he would not fight such a subpoena.
I promise this right back to you.
Thank you so much for being here. If you look into your crystal ball in view of the now 40 seats, the blue wave, do you think that some of the Republicans will actually wake up and join you and decide that maybe their future is not so secure and that their seats may be lost unless they, let's say, cooperate?
I'm rather pessimistic on that. And I'm pessimistic because the Republicans who prevailed are in very Republican districts. If they weren't in a very Republican district, they probably didn't prevail. There may be a couple of exceptions, someone who's very popular, et cetera, the basic dilemma a Republican faces is that he's got to answer, or she, to a Republican primary electorate. The Republican primary electorate is shrinking, and there are a lot of Republicans who've left the party, are now Democrats or independents, but they don't vote, those people don't vote in the Republican primaries anymore. So the Republican primary electorate is feared by the members, and the Republican primary electorate is at this point taking on the characteristics of a cult group. And that's what we're going to have to fight. So I'm pessimistic that we'll see too many Republicans. I mean, the real question isn't the Republicans in the House, it's Republicans in the Senate. Do we see Republicans in the Senate start asserting their independence on various things? And I'm very skeptical there, too, for the same reason.
Mr. Benoit.
If Matt Whitaker is still Attorney General when you become chair,
Say again?
if Matt Whitaker
He's still Attorney
is
General.
still Attorney, will you challenge his appointment?
Well, I've said that we will call him as our first witness to ask him a lot of questions, but his appointment has already been challenged. It's already been challenged in court, and that's the best way to challenge it. It's been challenged by 3 Democratic senators, filed a lawsuit 2 days ago. They have better standing than we in the House do. Their standing is the same. You know, Senator Blumenthal and I are leading, I suppose I should say, a lawsuit on the emoluments clause, and we asserted standing in that the Constitution says that the President may not accept a gift from a foreign potentate, et cetera, without prior consent, without consent of Congress. And so we have been deprived of our right to vote on that as individual members of Congress. And the court ruled in our favor on standing, which is the biggest hurdle. Here, the Senate has the right and the duty to advise and consent on a nomination, and therefore the senator's argument on standing is the same argument. They're being deprived of their right to vote on this. We in the House do not have the same standing argument. We have a standing argument, but a much weaker one. But they've launched that lawsuit. There are a number of other lawsuits, and I think that that's the way to challenge Whitaker's legitimacy. I mean, we could hold a hearing, we can yell and scream, but we can't vote on that.
I just want to say, speaking of standing, and Jerry's been a public servant for 40-plus years, Mr. Penoyer has special standing because he was in the Justice Department under the Eisenhower administration.
Wow.
And then in front. Agreed.
If you subpoena Trump's tax returns and you find out that he's nefarious, what pragmatic use can you make of this information?
Well, we can't subpoena Trump's tax returns, but the Ways and Means Committee doesn't have to subpoena it. There's a law dating from 1924 after the Teapot Dome scandal. I'm sure everybody remembers the Teapot Dome scandal, that says that the Ways and Means Committee in the House, the Finance Committee in the Senate, or the Joint Economic Committee can get anybody's tax returns upon request. So the Ways and Means Committee and Democrats on Ways and Means have made repeated requests. They've been voted down in committee. Now, in the first week or two, I'm sure that Ways and Means will vote such a request. It'll probably be fought in court, but I don't think there's much grounds for fighting it, so it probably won't go that long. And they will get the tax returns. Hopefully, there seems to be some legal question whether they can make it public. I think they can. There are a lot of questions, a lot of things we want to look into over there. For example, and first and foremost, to what extent, if at all, I believe it to a great extent, but to what extent is this president beholden to the Russians from business dealings? What do they have over him financially, never mind in any other way? That's a very thing you want to see. You'd also want to see adherence to tax laws, examples of legal ways in which the rich evade tax laws, examples of illegal ways. We may want to refer that to some other authorities too. But I think the basic question you'd want to look at is who has ties or not ties, who has a hold, who has influence on the President of the United States other than the American people through financial dealings. In order to not have that, that's why we generally require, that's why modern presidents all divest themselves of business interests. This president hasn't, and shows every evidence of being beholden to the Russians. So that we would want to look into very certainly.
Thank you again for coming. Jerry, my question has to deal with judges. We know that the Senate approves, but what role might you be able to have to look into some of the worser, that's not a real word, judges that are appointed by, Trump, and particularly as it relates to the possibility of additional Supreme Court judges?
With one exception, I don't really see that we have any role that we can do. The Senate certainly can. The one exception is that you saw in the Kavanaugh instance that serious allegations were made, obviously, and the FBI was supposed to do a check on this, and the FBI's check obviously wasn't the proper check. They didn't do a proper background check, and you know that because, it's almost a travesty when the FBI is investigating someone and doesn't interview the two principals, namely the accuser and the accused, And when you have 20 or so people who come forward publicly and say, I have testimony to give, please ask me questions, and they don't interview them. Obviously, the White House constrained that investigation. We will certainly look into that question, or into that, with a view, not to relitigating the Kavanaugh thing, we can't do that, but with a view toward making sure that the ability to constrain the FBI in reviewing a judicial or other nomination is placed under appropriate restraints so that that can't happen again.
Congressman, it's just a tonic to hear you run through the litany of concerns facing your committee. It harkens back to the period in the 1980s and Reagan years when House Judiciary was on the front lines of fair housing and immigration reform and disabilities legislation. And it's just incredible to think that there's a renaissance brewing.
Well, we have one house.
Can you comment on whether climate issues and issues relating to constitutional implications of technology and its increasing prevalence in our society will come before your committee?
Well, the constitutional issues and other issues raised by the, certainly the privacy issues and others raised by new technology will come before our committee. We're going to have to look into them carefully. We will consider a privacy law. What that will say, I don't know, but we'll hold hearings on that, and we'll look into that. We'll look at the European privacy law. I have no conclusions on that, but it's clearly an area that needs a lot of work. The whole question of the tech companies is partially an antitrust question. As I said, we're going to have a robust antitrust agenda that we haven't seen in decades. Actually, it's very interesting. People don't associate this, but Robert Bork wrote a seminal paper on antitrust policy in 1976, before he became infamous for other reasons. And antitrust enforcement in both Democratic and Republican administrations has basically followed his paper since then. And it has governed policy, and it has taken a very narrow view of antitrust, basically that you look at antitrust only through the prism of its effect on price competition, not the effect, for example, on competition for wages. And one of the reasons, there are many reasons, but one of the reasons why you don't see wages rising even in a low unemployment situation where classic economic theory tells you wages should rise, is because you don't have a lot of competition if there's only 1 or 2 employers in the field. So they're not bidding against each other for the workers. So we have to look at all those antitrust things, and that'll be part of well, it'll be beyond it, but also part of looking at the whole new tech world, which we have to do. And privacy is part of that too. The other part of your question was what? Oh, climate. Climate is obviously a crucial issue. It's not our committee. It is the Energy and Commerce Committee. And let me just say one thing. There have been some calls for a special select committee on climate change to look into this to give it more urgency. I'm somewhat skeptical of that because a select committee might result, not deliberately, but might result in actually slowing down what you do. If you have, as we do, a committee chairman in Frank Pallone who's very committed on climate change issues, and a committee majority that is committed on that, they can do the work. Adding additional jurisdictions, might just add an additional layer of red tape. So that's a secondary question, whether you should have that or not. Some people, some progressives think we should add a special select committee to show our resolve, and because there was a select committee years ago, I'm not sure that would actually enhance things. It might hinder them, but we'll see about that. But the Energy and Commerce Committee in the House under the Democratic majority will be very, I expect it to be very energetic on that.
No problem.
No pun intended, yes.
I think we have time for 2 quick questions. You had your hand up, and then
Thank you very much, Congressman. It's nice that one House of Congress will will be populated by people who speak in complete sentences next year. But I have two questions that I think are very much related. One, in light of the fact that the Democratic majority in the midterm elections was somewhat north of 8 million votes, but our majority is about 17, 18 seats.
Well, the majority is 17, 18 seats above the majority, but we have probably 35 or 40 more than the
No,
Republicans.
I get that, I get that, but I guess, but the question I have specifically is what are your plans to deal with gerrymandering and voter rights, voter access specifically? And the second question, which is not a question of what your committee can do, but more your personal thoughts on what may be a developing constitutional issue, which is as the population demographic shift to larger concentrations of people in smaller numbers of states, you get the exaggeration of the influence of smaller states through senatorial, two per state. I know that when the founding
And the
fathers-
Electoral College.
and the Electoral College. And I know when the founding fathers, of course, did it, Maryland and Delaware were pretty concerned about New York and Virginia, but times have changed, and I wondered what your thoughts on that are.
And that's your second question. What was your first question again?
On gerrymandering.
Gerrymandering. Gerrymandering. Gerrymandering is obviously a distortion, and we had hoped before Justice Kennedy retired that the court would essentially throw it out. That is not going to happen. Congress could act on that. Congress has jurisdiction over federal elections, so we could have legislation to prevent gerrymandering with respect to federal elections. Couldn't do that with respect to state elections, but with respect to federal elections, Congress could do that. We are developing a bill called H.R. 1, which shows the priority, which will deal with a lot of questions of voter suppression, voting rights, gerrymandering, all these different issues, campaign finance reform, overturning Citizens United, which is a constitutional amendment. We're going to put that all in one major bill. It'll be the first, H.R. 1, the first bill that's introduced, and we're going to deal with all of those questions, not just voter suppression, the renewal of the Voting Rights Act, section, pre-clearance requirements, all of that. How much of that we can get through the Senate is obviously a major question, because the Republicans at this point rely on voter suppression and on gerrymandering, and have make no bones about it. I'll say one thing. In 2006, we renewed the Voting Rights Act. Steve Shabbat, who was then the chairman of the Constitution Subcommittee, and I was the ranking member, the two of us sat through several hundred hours of hearings to establish, we amassed a 15,000-page record because the Supreme Court had said we needed a major record. I never thought that was the right decision, but nevertheless, that was the Supreme Court. And we passed a 25-year renewal of the Voting Rights Act in 2006, and we did that even though we didn't have to do it until 2007, because the chairman of the committee, a Republican from Wisconsin named Sensenbrenner, who was term limited as chairman, was afraid that his successor the year later might not do it. So we did it. We passed it through the House. We passed it through the Senate. The House passed it 395 to, 30 or whatever. 25-year renewal. 5 years later, or no more than 5 years later, I think it was 2013, whatever it was, Supreme Court in Shelby County came out and threw out the pre-clearance requirements, which is the heart and soul of the Voting Rights Act. But they didn't do it on constitutional grounds. They did it by saying that the test that we were using for which jurisdictions were subject to pre-clearance was unconstitutional because it was outdated. And they invited us. They said, give us enact a more up-to-date test, and that'll be fine. Since then, we've been unable to get Republican votes, although we had 395 votes, almost all the Republicans. Once that happened, we've not been able to get Republican votes on that at all. We will pass such a bill in the House. It'll be part of this H.R. 1, but it's a major struggle to get it through the Republicans these days, who are dependent on voter suppression. There's gerrymandering. What was the other thing you asked? Senate representation. Senate representation, very quickly. There are two issues here. One is much easier than the other. Senate representation, it's the only provision in the Senate in the Constitution that cannot be amended by normal constitutional amendment. The Constitution says no state without its consent shall be deprived of its equal representation in the Senate, which means you'd need all 50 states to agree. That's not going to happen. So we're stuck with that, period. I don't know of any way of avoiding that. On the Electoral College, we're not going to pass a constitutional amendment, but there is something called the National Voter Initiative. You know that, as a general rule, except for Maine and New Hampshire, Maine and Nebraska, which I won't go into, a slight deviation, if you carry the vote in New York, you get New York's electoral votes. Most people think that's constitutional. It is not a provision of the Constitution. All the Constitution says is that there should be a number of electors in each state equal to the total number of senators and representatives. So we have 27 congressmen, 2 senators, we have 29 electoral votes. And the electors shall be selected in a manner determined by the legislature thereof. Since 1828, every legislature has said our electoral vote shall go to whoever wins the plurality of the popular vote in our state, but they don't have to. A state legislature could pass a law that says we won't bother having an election. The governor will appoint the electors, or the attorney general will, or the first 26 names in the Manhattan phone book, whatever. They have a carte blanche to do whatever they want. Since 1828, we have that. There is something called the National Voter Initiative, which is an attempt to get states to pass a law that says our electoral votes, or technically the slate of electors from our state, will be elected based on the national popular vote. Whoever gets a majority of the national popular vote will get the electors from our state, provided that this law goes into effect when enough states totaling a majority of the Electoral College, 270 electoral votes, have passed a similar law. So if you did that, then New York's electoral votes would go to whoever won the national vote, as would others. So far, states with 165 electoral votes, 270 being a majority, states with 165 electoral votes have passed such a law. We need another 105. We've gotten the easy ones. The others will take time, but hopefully eventually will be, especially if states like Florida and Texas turn blue, we can get them to vote that way. And we can get 270 electoral votes. That would, in effect, for practical purposes, give us a national popular vote, although the vestigial electoral college would still be there in a vestigial form. Thank you very much.
Thank you, Congressman. I'm sorry we had to cut it short, but we have our student schedules to respect. All of our guests are invited for coffee upstairs. Our students are invited to the second floor for lunch with Congressman Nadler. I want to thank our Board of Advisors members, Tony Stepanski and Norton Garfinkel, and Ambassador William Vanden Heuvel for being here. For those of you who think that Jerry Nadler is just in it for the first 100 days, I just want to say that Jerry and Joyce are the grandparents of a new grandchild. They're in it for the long haul. Thank you all for coming. Happy holiday.